Welcome to Atlanta Business and Commercial Real Estate Law Podcast.
Welcome back to the Atlanta Business and Commercial Real Estate Law Podcast with attorney Mark Battleson of Battleson Law, LLC. Mark brings over 3 decades of experience across business law, commercial real estate, and deal structuring with a background that includes both legal work and hands-on business roles. I'm Lisa Mosby, and today we're talking about loan defaults and workouts in Georgia and how business owners can respond before things escalate. Mark, thank you so much for joining me again today.
Good to see you, Lisa.
Mark, what are the early warning signs that a business is heading toward a loan default, even before payments are missed?
Well, it's not a legal question, if they're with regard to most loan defaults, which are generally what are called monetary defaults, like non-payment. There can be other kinds of loan defaults, which we may get into later, that are non-monetary defaults, but typically a big or small business, companies get into trouble because they either have some external problem with revenue, or they're not properly managing their expenses. But it really just comes down to you either need to have sufficient cash flow in your business to be able to make all of your payments, be it on a loan or vendors or otherwise, or have lines of credit that can help bridge those gaps, so that you can service the primary debts of the company or obligations. So I guess the signal is you better be able to monitor your cash and run a proper business, because it's like a cardiac arrest when you run out of cash. I mean, the company just seizes up, and then you're dancing on the head of a pin trying to get vendors to still supply you, while you're trying to put off paying debts. You've got payroll obligations, sales tax, etc. And companies can spiral out of control if they don't run a tight ship.
And I remember those early lessons in business. Cash is king. Never run out of cash. Figure out how to get credit. Yeah.
Yeah, I mean, credit is great, but all that does is just kick the can down the road. Operating cash flows are what matters. I mean, revenue minus your expenses, and it better be positive, or ultimately you're going to run out of runway.
For sure. And once a default is on the horizon, what options are typically available to a borrower before the lender takes formal action?
Well, yeah, I mean, and each lender is going to be different on how aggressive they are, but ultimately they're in the business of lending money out and getting paid back and making interest margin on that. So, the second you anticipate a problem that you really can't cure, through either external sourcing or just maybe in a short course of time you can cure it and fix the problem. You really do need to do an evaluation of your business and then present something to the lender saying, hey, look, things are tight. I am going to be struggling to make payments. I want to talk to you about maybe a forbearance or some kind of work kind of prepackaged workout before you go into default. Sticking your head in the sand and then hoping for better days usually doesn't work. I mean, you could end up, maybe your business takes a miraculous turn, but if you can't foresee that you're going to be able to just maybe have a bad month or two and be able to fix a monetary default, you're much better off engaging with your lender, being responsible. And then you need to provide a viable path forward to where you're going to get yourself back on track and be able to show that this is just a blip on the radar and not a permanent decline of the business to where you're ultimately going to be in default.
And lenders are under no obligation to work with business owners. But from a lender's perspective, what usually drives the decision to work with a borrower versus just moving toward enforcement?
Well, I mean, it's their belief that they're actually better off by working with you, right? So how do you convince a lender? You convince the lender to give you a loan on the front end, regardless of what kind of lender they are. Could be a vendor, it could be a bank, it could be a non-bank financial institution, just some credit provider. But somehow you convince somebody to issue you credit, and so therefore, you need to be able to reconvince them that they may have made a mistake, but you're at least responsible enough to cure it, or that there's sufficient collateral there, or through a guarantee, personal guarantee on this, that there's a high likelihood of them getting paid back. People don't like admitting their mistakes, whether they're lenders or borrowers or just general people. It's human nature. And so,
It
to
is.
the extent that they either have obligations to their bosses upstream, they may be looking to, um, you know, provide a solution in advance of going to their boss and saying, "Hey, look, we've got a problem here with this loan. We've already talked with the borrower, and we're going to come up with a solution that's going to help bridge the gap." And then that lender, whoever is servicing that loan, the individual or team, is going to just want to see that, hey, look, us giving extra time isn't going to hurt us more than acting right now. And so some of it's on faith, some of it's on not wanting to admit when you've made a mistake on the lender side. And and enforcement has significant expense with lawyers on the banks if they do initiate a lawsuit or try to deal with the defaulted loan. um, they may get less back if they get super aggressive, because then the business goes into a tailspin. And it may be better off that they may be better off if they provide some level of relief or forbearance and let the business live to fight another day and live to make another payment.
And I'm sure all of that is on a case by case basis because you just don't know. But, during workout discussions, they can take different forms. What does a typical loan workout look like in practice? And how do those negotiations usually unfold?
Well, yeah. So I think whether you get a lawyer involved or not, getting a lawyer involved shows that you're serious about trying to resolve this. And if you've got a $3,000 or $4,000 outstanding loan, you shouldn't be hiring a lawyer to deal with that. You just got to suck it up and deal with it. But if you've got hundreds of thousands of dollars of business debt out there and maybe multiple lenders, then having a coordinated engagement of an attorney helps identify the seriousness of it, as well as provide some level of skill and uh, guidance to the borrower. So the typical way that I would handle it is, you need to understand, okay, what are all the liabilities? You got to kind of stack them up and say, all right, what are the liabilities? What's in default? What is not? What are the daily or the monthly obligations to this debt, as well as the total obligations? If there's a personal guarantee, you need to assess that and understand what is at risk for the personal guarantor. I mean, if they're broke, then you can't get blood out of a turnip. And so, it's just something that you can let the lender know. Hey, look, you're not going to get much anyway, so let's work this out. And maybe if we live to fight another day, you're going to get more money. But the ultimate situation, and it kind of goes back to the initial statements that I made, is the business needs to be viable going forward and have a path to correct the problem in order to encourage a lender to believe that they're going to be better off by providing some time relief, forbearance, which just means either a delay or a reduction in payments. There may be an abatement, but I doubt that. An abatement is more like free rent, rent on leases, but free, maybe a reduction in the principal. Typically, that doesn't happen unless it's a full-fledged settlement and the business is shutting down. So that's something we really haven't talked about, but we'll maybe get to with you can settle out debt if the business closes down, and in particular SBA debt. There's what's called an offer and compromise process that the SBA has to approve on top of the lender. But the hope is that the business survives and doesn't have to do a wind down, which has all kinds of consequences with landlords and other creditors beyond the loan that you're in default on.
And you mentioned the word personal guarantees. We've all been there as entrepreneurs and had to put our own personal situations in the line of fire. But how do these situations factor in when a loan is in trouble? are you in trouble too, personally?
Yeah, I mean, if you've signed a personal guarantee, they're very standard. I mean, they're you can negotiate those, and I encourage clients to try to negotiate as much as possible on a personal guarantee on a loan. But the I use this phrase all the time. Lenders want a warm body and a beating heart. That being a human being that they can sue in the event that the LLC that they've lent money to just goes under. A lot of LLCs do not have that many assets, in particular service businesses that don't have a lot of equipment or real estate or otherwise. So somebody could borrow, $1 million through an LLC, and there could only be 10 or 15 or $20,000 of physical assets. The space that they're operating out of, if it's got a physical presence, is a lease usually. So that's not an asset, that's a liability. So the personal guarantee comes into play because if you're going to loan somebody or loan an LLC money, you don't want them to just shut down and then you've got a hollow corporate shell there to go after and the money is gone. Either it's been spent or even in a worst case scenario has been spent personally for non-business uses that the loan was intended for. So the personal guarantee kicks in, and if that person has assets, which typically a lender is going to underwrite the creditworthiness of both the borrower and the guarantor. In the event that there is a default, they want to know, hey, what do we get? What is there to get from somebody in the event of a default? That's important. But then going back to the warm body and beating heart situation is the personal guarantee is valuable just because no one wants to default on an LLC loan and then have that guarantee kick in and there's a $1 million judgment for a loan default against the individual. You can't get out of that personal guarantee without filing for bankruptcy. And, there's a stigma to bankruptcy as well as just, functioning in society. If you have a bankruptcy, you've got 7 years of basically not being able to get consumer or personal credit for a personal bankruptcy. So the guarantee, yeah, it's a big risk. If you own real estate, it's a risk. Even if you're married, there can be lenders that can put a judgment lien on property, and even if you own it jointly with your spouse. Usually, a smart lender is going to require that if you have a house with a spouse, they're going to require, even if that spouse is not a borrower and not signing a guarantee, but give permission to provide that real estate as collateral for the loan. So there's a lot that goes into it when you're dealing with this. And it happens a lot in the SBA realm. SBA lenders want a piece of real estate collateral if the loan's greater than $300,000.
And I know, Mark, that timing can make a big difference. How does engaging with a lender early change the range of outcomes compared to waiting, like you said, burying your head in the sand, waiting until the situation becomes more urgent?
Yeah, the old saying, "A stitch in time saves nine." It's kind of works in this situation too. Is if things are going bad and you want to present yourself as an honest, uh, diligent, well-intended borrower that's trying to, fix your problem as the borrower, as well as thereby help the lender out and not having just a $0 return on a loan. Getting involved early, signaling, A, we have a problem. B, here's the vision for how we're going to we, the borrower, are going to fix this problem. And we just need a little bit of breathing room on, like, if you don't have the cash, you can't make a payment. And so if you are honest with that lender, they're going to know when you don't make the payment anyway. So you might as well get ahead of it and say, hey, listen, I got a payment due in 2 weeks and I cannot see how I'm going to have the cash to be able to make that payment. So I'm signaling this now so that we can get out ahead of it. And you can see that I'm just not sticking my head in the sand and ignoring the problem. Sticking your head in the sand and ignoring the problem and just going to default, well, that just that lights the fuse toward a lawsuit against the borrower and the guarantor, assuming there's a guarantor. And either the business is going to go down in flames with a judgment against it and then collection efforts, or possibly the guarantor. So getting out ahead of things, and then whether you hire an attorney or not, you can't solve problems with zero cash. So If you're flat broke, there's nothing I can do for you. And if you're going to have to solve these debt problems with some form of workout and payoff. Otherwise, what's the incentive for the bank to do anything? You just say, hey, look, I can't make a payment, and I'm never going to make a payment. So, but I'm at least letting you know that. Well, I mean, that's polite, I guess, but it's not going to solve your problem. And then the lender's going to have to do what they are required to do, which is try to maximize dollars under those loans. And they're going to pursue guarantees. They're going to try to levy or garnish capital or assets of the business to the extent that they exist. If there's a lien, they're going to exercise their rights under the lien. And that is not being a, quote, bad bank or anything. That is called proper business execution as a lender.
You mentioned lender rights or rights in their contracts. Loan documents often include lender rights, but they don't get much attention at the start. People don't really pay attention to it. Which provisions tend to matter most once a default is in play?
Well, I mean, yeah, there's a loan agreement and a promissory note usually, and then some extraneous other documents associated with that. And maybe a security agreement, which would be the right to then file a UCC-1 lien. But the rights and remedies they're very basic. I mean, it is, hey, we're giving you a bunch of money. You're going to pay us interest and principal on this timeline, maybe an interest-only loan, and then you pay a balloon payment on the back end. Maybe what's called a fully amortizing loan. A lot of SBA loans are fully amortizing, which is principal and interest, kind of like a mortgage, and they're 10-year terms typically for 7A loan. So it just depends. But like the rules are, hey, you need to show us that your business is viable when we request it, or maybe on an annual basis. So you've got to show profit and loss statements. You've got to show potentially on a guarantee, there may be a provision in there that says you have to have a minimum net worth or a minimum liquidity. Net worth is different than liquidity. Liquidity is essentially cash, what you can access quickly. And so depending on the nature of the loan, depending on the nature of the debt obligation, if it's some other structure, you could have profit and loss requirements or liquidity requirements associated with that loan for the company and or the guarantor. You could have a whole other set of conditions that are, quote, non-monetary default situations. And again, monetary default is you didn't make a payment, generally. There could be some other tangential trigger on that. But so monetary defaults are easy. But you could default and have all these other, and that this doesn't even get into the remedies where you're talking about the enforcement. But you could have a series of defaults that are non-monetary that just create a higher risk loan for the lender when your collateral or creditworthiness goes down. And they may even have, in more sophisticated, Wall Street type loans, they've got call options, or you have to post up additional collateral if your collateral deteriorates. So that's not typical on more small business loans where I deal now, but I used to deal in a much more sophisticated kind of financing structures. So going back to the question of the remedies are exercise rights under a lien, sue, or exercise rights under the guarantee and sue. And so usually the lawsuit goes against both the lender and the guarantor at one time. But I've had clients that have, where their entity is filed for bankruptcy, but they haven't filed for personal bankruptcy, and they're still exposed to the lawsuit as the guarantor of that original loan. And then we've had to work things out with that because maybe they do have assets. And you just got to cast the wide net, understand the entire universe, and then try to, through experience and education and diligence of looking through the exposure, okay, how are we going to try to get this resolved? But the bank can easily sue on almost every situation where there is any kind of a default. It doesn't have to be just a non-payment. It can be one of these non-monetary defaults I mentioned.
Mark, I'm going to leave it there for today. Thank you so much for your insights and your guidance through this process. We've learned cash is king, and if you run out of cash, there's not much else you can do.
Yep, I agree. Great to see you, and I'll look forward to our next one.
Folks, That's it for today's episode of Atlanta Business and Commercial Real Estate Law Podcast. If you're dealing with a loan issue or trying to navigate a potential default, you can visit battlesonlaw.com to connect with Mark. Thank you so much for listening. Be sure to like, leave a review, and subscribe. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.